What did the veterans say? Who's first down? Is it I?
You. You're first. You're first. Don't pull your chair out. You break right, right?
All rise. The Court of Appeal in the 4th and 5th District of the State of Florida is now in session. The Honorable Harvey L. J. Chief Judge presiding. All persons that have business before the court draw near, give attention, you will be heard. May God save the United States of America, the State of Florida, this honorable court. Please be seated.
Good morning. Welcome to the 5th District Court of Appeal. We have two oral arguments this morning, and I am Harvey J., as you just heard from our marshal. I'll be presiding for both cases this morning. To my right, Judge Edwards, the immediately past Chief Judge of our court, and to my left, Judge John Harris, longtime Chief Judge of the 18th Circuit. These two esteemed colleagues are obviously an important part of this court. Remember, this is a courtroom, and what goes along with it being a courtroom. So if you would be kind enough to make sure your cell phones don't go off in the midst of that, of the OAs today, that would be appreciated. If the advocates would be careful to listen to our questions, please try not to talk while we're speaking. As you all know, part of why you're here is to answer our questions. And so if you do not do that, that defeats one of the purposes we have you here for. The last thing, we will not take a break between cases, but we will give counsel an opportunity to leave the courtroom. If there are spectators here, not a big crowd, but if you would be kind enough maybe before the next case to leave, if you're here for the first case. The reason I say that, it's disruptive to have people leave the courtroom in the midst of argument. That's not good for the court, it's not good for the advocates. So if you are here for the first case and would like to leave after that first case, it would be appreciated if you would leave at the short break where we transition the new lawyers in. and then we can get started with case number 2. But the first case this morning is Cruz, case number 2025-0232, and on behalf of the appellant, Ms. Baden, would you like to reserve any time for rebuttal?
Yes, Your Honor, 5 minutes.
All right, so noted for the record. Please proceed.
Good morning, Your Honors, Chief Judge. May it please the Court. My name is Rachel Batten, and I am the attorney for the appellant, Michael Cruz. Mr. Cruz comes before this Court to respectfully ask for a reversal of the trial court's order involuntarily dismissing his petition for guardian advocacy based on a lack of case jurisdiction. We request that relief based on 3 separate points. First, equity. Second, inapplicability. And third, the law and public policy. Just a brief factual background for the Court. James Vincent Cruz, who I'll refer to as Vinny, is the adult autistic son in common between Mr. Cruz, the appellant, and Helen Waischke, the appellee. They both initially petitioned for a plenary guardianship over Vinny, seeking appointment as his guardian.
This case is all about case jurisdiction.
Yes, Your Honor.
Can you differentiate case jurisdiction from subject matter jurisdiction?
Your Honor, I certainly can, but I think the Florida Supreme Court did that for me. We did file.
And I read the opinion. I'm sure my colleagues did too. You're talking about the Schmidt case, the LaBarga opinion that just came out over the summer.
Yes, sir.
So as I understand, subject matter jurisdiction is something that can always be raised with the parties, whether the court has the power to adjudicate a matter. But within that band of power, there are cases, case jurisdiction, whether the court has jurisdiction over a particular case, even though they will have, the court has subject matter jurisdiction over the whole swath of cases, but the particular case is whether or not the court has case jurisdiction. Is that a fair synopsis of what we're speaking of?
Yes, Your Honor, and I think the very crux of the difference, which is important in this case, is subject matter jurisdiction is not waivable because it deals with the court's power to adjudicate a particular issue. The Florida Supreme Court in JJJ-TB versus Schmidt said case jurisdiction is waivable, and a party failing to timely raise an objection to case jurisdiction in the trial court has therefore waived that objection. In this particular case, the record contains no reference to case jurisdiction, no motion to strike, no writ of prohibition, no motion to dismiss for lack of case jurisdiction. It was not even addressed at the motion to dismiss hearing, which dealt specifically with personal jurisdiction. Instead, it was raised by the trial court in its final order issue.
Is that not a distinction without a difference? I mean, the jurisdiction was raised. I know not the term case jurisdiction, but jurisdiction was raised. That's why we're here. Had it not been raised, there wouldn't be an adjudication on that, would it not?
Your Honor, personal jurisdiction, also subject to waiver, and subject matter jurisdiction are distinct in this particular case.
Understand, and I think we all agree. There's subject matter jurisdiction, there's case jurisdiction, and there's personal jurisdiction. All different, all multi-variegated in their definitions. But jurisdiction was brought to the court's attention here.
Only personal jurisdiction, and we were never heard on the issue of case jurisdiction. And in the, I'm going to refer to it as the Schmidt case, Your Honor, if you don't mind, because there's a lot of letters.
Yeah, I refer to it to avoid the acronym.
And in the Schmidt case, the Supreme Court specifically pointed to a public policy reason for its basis to find that case jurisdiction was waivable. And that is essentially when a party knows there's not case jurisdiction and does not bring that to the court's attention, therefore leveraging the litigation. In this particular case, Ms. Waischke, after Mr. Cruz filed his petition for guardian advocacy, sought documents, the request for production, sought interrogatories, took and set his deposition. Vinny's attorney sought court-ordered mediation. Mediation was held, and litigation went on for 2 years, just like in that Schmidt case. And the court said that setting a precedent where we would allow parties to conceal these errors of case jurisdiction leverage the litigation, and then get an adverse outcome, only to then, for the first time, raise the issue of case jurisdiction on appeal, would set a bad precedent and would allow litigants to essentially leverage jurisdiction as a weapon.
And I obviously saw that in Schmidt, read Schmidt, but that was an appellate gotcha case, was it not? Did we have an appellate gotcha here? I mean, jurisdiction was raised. I know it wasn't case jurisdiction, it was personal jurisdiction. Jurisdiction was raised. That was the reason the court dismissed the case, was case jurisdiction, was it not?
Jurisdiction was raised, Your Honor, but I think, again, the Schmidt case makes it very clear that personal jurisdiction, subject matters jurisdiction, and case jurisdiction are wholly distinct.
Why did the trial court dismiss this case?
The trial court dismissed this case for lack of case jurisdiction.
So there you go. Was there a motion for rehearing filed to that saying that it was waived?
No, Your Honor, there was not a motion for rehearing.
Isn't that a waiver of the waiver?
So, Your Honor, 2 points regarding the motion for rehearing.
Yeah.
So, first, the motion for rehearing is not found, interestingly, in the Florida probate rules. There's only a vague reference to it regarding a time frame. So, unlike other areas of law, there isn't a robust structure set out in the Florida probate rules for rehearing. Secondly, this particular issue raises a fundamental error.
And I appreciate that. I appreciate the unique situation where we haven't adopted all the rules of procedure into the probate rules. But so there was no motion for rehearing, no motion for reconsideration?
No, Your Honor, there was not.
Was there anything to bring the court's attention to the fact that the position of your client was that case jurisdiction had been waived?
Your Honor, at the time that the order was issued, Schmidt had not yet been promulgated by the Florida Supreme Court. There was a split in the jurisdictions, the 4th District saying it could be waived, the 2nd District saying it could not be waived, and this court had not yet weighed in on the issue, so there was no controlling authority to bring to the court's attention regarding the waiver issue. We now have Schmidt, which says unequivocally that failure to raise the issue is a reversible error, or failure to raise the issue, it's causes reversal on appeal. And
Counsel, can I interrupt you for a second? Even if you lose on the waiver issue, do you think that's it? You're done, or do you think the judge got it wrong?
No, Your Honor. So the waiver issue dealt with my first point of equity. There are 2 alternative arguments to be made for reversal.
Let me ask you some timing issues, if I could, and if you need to look at them while you sit down waiting on your rebuttal time. Here, the joint petition was filed to have him declared incapacitated August of 2022, correct?
I believe so, Your Honor.
All right. And then Mr. Cruz filed 2 things in one e-filing. I looked to see if you could even see a second difference between them, or if there was a difference on, I don't know exactly what the word is, but the code. You get a code almost like a receipt number. So these 2 pleadings were filed at exactly the same second according to e-file and exactly the same receipt number. But on March 10, 2023, Mr. Cruz filed his motion for appointment as guardian advocate, and he also filed at the same second, by the magic of electronics, his notice of dismissal, his part of the joint petition, which said in the title and in the body, I'm dismissing my part of the joint petition and intend to file a guardian advocacy petition, which he did at the same second, correct?
Yes, Your Honor.
Then March 24, 2023, Ms. Waschke files her motion for guardian advocacy, correct?
Yes, Your Honor.
Okay, so you've got all those motions are pending, for 2 motions pending to be appointed guardian advocate, correct?
Yes, Your Honor.
And it's in September of 2023, Ms. Waschke files her amended motion to dismiss regarding personal jurisdiction or perhaps venue. Wasn't that clear? And it's not until March of 2024, a year after Mr. Cruz files his papers, Ms. Waschke then dismisses her part of the joint petition, correct?
I believe that is correct, Your Honor.
Well, you can double check these. And then January of 2025, 9 months later, whatever it is, that's when the court finally dismisses the case. But when he dismisses the case for lack of case jurisdiction, there are pending 2 motions for appointment as guardian advocate, aren't there?
Yes, Your Honor, one filed by Mr. Cruz, and then I believe it was titled as a counter petition filed by Ms. Waischke approximately a week or two after Mr. Cruz's petition.
And both of those guardian advocate petitions were filed while Ms. Waischke's part of the joint petition was still pending because she didn't dismiss hers until March of 2024, a year later. And again, feel free to double check that, but assuming those are correct, and I can give you some guarantee on that, but there was a lot still going on in this case. This was not like a case where somebody goes in, dismisses their case, goes home, and everything's done. When Mr. Cruz withdrew his part of the petition, he immediately, at the same time, literally the same second, same filing, filed, here's this motion, I wanted to be appointed as a guardian advocate. And you can be appointed as guardian advocate without a declaration of total incapacity, can't you?
Yes, Your Honor.
So this was not a case where nothing was going on because the parties had dismissed everything and then they decided to start over, is it?
No, Your Honor, and that brings me to my second point about inapplicability related to the case relied on by the trial court to dismiss Mr. Cruz's guardian advocacy petition, which is the Kottke versus Birch case. In that particular case, there was that intent, that clear abandonment of litigation, that expression to withdraw all pending motions, all pending pleadings, all pending requests for discovery, saying, I am requesting no further relief from this court, I am done with my litigation. And then a person who had only become involved in the case after it was initiated tried to essentially piggyback off of that withdrawn petition and file their own petition for incapacity. So that particular case is essentially inapplicable to the facts that we have here because there was no intent by Mr. Cruz or even Ms. Waischke.
You like the Howard case better, don't you?
I don't know if I would say I like it better, Your Honor. It does exist. I do think that perhaps there might be a little bit more facts to help guide us in our analysis, but the facts in the opinion are what the facts are. And the court's recitation of the subject of the particular proceeding, I think, is applicable to our particular case and goes to my third point about the law and the public policy involved in these particular types of cases when we have guardianship or guardian advocacy related to incapacitated individuals.
When Howard, the mother, father, and brother jointly petitioned to take care of the daughter and sister because she was incapacitated, and they filed a petition for incapacity and also to be appointed as guardian advocates, didn't they?
Yes, Your Honor.
And although there were other issues in the case was not dismissed because of a lack of jurisdiction, was it?
No, Your Honor. So the case actually was not dismissed. The court did find incapacitation, which is under 744, and then also appointed a guardian advocate under 393. And it was reversed by the appellate court because the order did not comply with the specific statutory requirements under 393. That case can be read potentially for the idea that there can be a request for incapacitation that can result in the lesser restrictive alternative of guardian advocacy, which comports with the legislative intent that is replete in 744.
As we talk about cases, we've talked earlier about Schmidt, which was your, a notice of supplemental authority, and then we got a second notice of supplemental authority, Pino. How does Pino play into any of this?
Your Honor, I don't presume to know why the appellee may have filed Pino. Pino specifically discusses whether or not the court can set aside a plaintiff's voluntary dismissal based on a request from a defendant. When the defendant alleges, after litigation has ceased, based on that voluntary dismissal, that there was some type of a bad act or fraud on the court. I would have to defer to my opposing counsel as to why they filed that particular opinion. I apologize, Your Honor, I can't speculate.
Well, I read it again, and it's, well, better keep my mouth shut, but it's a long opinion, I'll put it that way. But it does, a lot of it's predicated upon the rule, which does not overtly apply to this case, correct?
Correct, Your Honor, and that brings up another point regarding the Kottke case. So in guardian actions, they are meant to be non-adversarial because the intent is to protect these vulnerable people. And there is a particular rule, a probate rule, which allows the court to either find a action as adversarial because of what's going on in it. There are some that are deemed adversarial by their very nature, and then the parties can declare it to be adversarial. And if it is triggered under that rule, then the Florida Rules of Civil Procedure apply. But in this particular case, none of the parties declared it to be adversarial. The court, unlike in Kottke versus Birch, did not declare it to be adversarial, and the particular matter pending before the court did not meet any of the requirements of the rule to essentially be deemed per se adversarial. If there are no further questions, Your Honor, that is my time, and I would like to reserve the remainder for rebuttal.
Thank you.
Thank you, Your Honor.
Good morning.
Good morning, Your Honors. My name is Robert B. Asadi, and I represent the appellee, Helen Waskey. I don't represent the ward, James Vincent Cruz, called Vinny in this case. He was represented by another counsel who didn't file a brief in this record, but she relies on the report that she filed that the trial judge relied on in making her decision. Judge Edwards, I think it was you that said, you look at the top, look at the top of the petition. There was a joint petition filed in this case, pro se, by two people without representing. It's filed in the exact same thing as their notice of appearance where Ms. Batten represents Mr. Cruz. It's the pro se thing filed with her notice to represent the husband. And the wife, who thought this was former wife, they've been divorced for 20 years, thought this was going to be non-adversarial. And then it became adversarial when the father wanted to take custody of the son. Now bear in mind, this is not a child thing. He's 29 years old. The record shows he's 6'4", 220 pounds. He's not a child. And the mother has had custody and taken care of this young man for his entire life. The son has lived with the mother from the divorce when he was 9 until when his attorney took his, not deposition, but interviewed him 20 years later when he was 29.
And he still indicated he wanted to live with his mom, correct?
Absolutely. And made it.
Was my timeline correct from what
Your
you just said?
timeline is correct, but I throw you to this is a little different, because you're talking about the motion to amend done later. I'm talking about the very first filing in this record.
Well, let me ask you about that too, and follow up on what Judge Edwards was asking about the continuing jurisdiction.
Yeah.
At the outset, there was this joint petition for incapacity.
Correct.
And you're saying the court lost jurisdiction when that was voluntarily dismissed.
By him, yes.
At the same time, though, there was a joint petition for guardianship filed. That was never dismissed by anybody. That still was pending the whole time, right? There were two petitions filed from day one, two joint petitions. The incapacity petition was dismissed by Mr. Cruz first and by your client, a year later. But the other petition was never dismissed by anybody, was it? Or am I just reading the record wrong?
I hate to say this, I just don't remember. I mean, the point is, when you voluntarily dismiss your case.
Well, he dismissed one of two.
But that's not a case. I mean, that's not a what's the case that's there? I mean, if there's
Petition to appoint a petition for guardianship.
But I think that's what he moved to dismiss. I could be wrong.
Well, it's not.
It is.
He moved to dismiss his portion of the incapacity petition.
No, what was dismissed from my reading of the record, and again, you correct me, and now's your time. They filed the joint petition for incapacity. Then like I said, at the same second, same receipt, same everything else, Mr. Cruz, you can't tell which was first. Maybe he dismissed his part of the joint petition for incapacity and filed his petition for guardianship, and then 2 weeks later, Ms. Waschke filed her motion for guardian advocate appointment, and it's not until a year after that that Ms. Waschke dismisses her part of the joint petition, March 14 of 2024. And to me, you know, again, this is not a case where somebody dismisses their complaint and everybody quits. This is more in the line of an amendment. I'm no longer, as Mr. Cruz, seeking total incapacity. I'm seeking guardian advocacy, which is, you know, the courts, the law is always look for the least restrictive means that still takes care of the needs of the incapacitated person. So it's almost like an amendment. I'm not seeking full incapacity. I'm going for guardianship. And then Ms. Waschke she doesn't dismiss her part yet. She goes, okay, well, if there's going to be a guardian, I want to be the guardian, which, again, is totally understandable for her to take that position. But you've got those two things in front of the court. Hey, we both want to be the guardian. Maybe we both can't be, but one or the other of us ought to be. That was before the trial court, and nobody ever moved, as appellant said in here and by filing that case. Nobody ever said, hey, wait a minute, there's no continuing jurisdiction here. And again, Ms. Waschke doesn't dismiss her petition, her part of the petition, until March of 2024, which is 2 years after it was filed and 9 months before the judge issues an order. So there's a lot going on still in this case, not to mention the discovery. This is not a case where somebody dismissed their case and went home. They dismissed a part of a petition and immediately, I mean, you can't get more immediate than what the timing is on the court stamps here with the e-filing. Immediately filed the motion to be appointed guardian. So this was not, I quit, I go home. So, but that's how the judge treated it. And
It's
again,
a long question.
What's that?
That's
It's a long question, sure.
I'll do my best to answer it if I
Okay.
can. Nobody mentioned the case of Katke versus Bershey, which is a case out of this court. And it says when a party, it's a writ of prohibition, and there was no writ of prohibition in this case, but it's very clear on this, and that's what the court relied on. The court said, look, this court said, if you dismiss your original petition, I have no jurisdiction to hear anything filed after that.
I understand that's what the case says, and it also says that the trial court must accept a dismissal.
Correct.
I'm not aware of that in any rule, really, are you?
Yeah, that's the case we filed as supplemental authority from the Florida Supreme Court, written by Justice Pariente, thank you.
When somebody dismisses their case, it's dismissed.
I don't...
Katke
guess.
says you have to have the judge accept a dismissal. Did the judge accept these dismissals?
No, actually, it doesn't say that. What it says is when you file a dismissal, as soon as that dismissal hits the mailbox, the case is over. That's what it says. When you dismiss
There's a big
case...
distinction that you're missing and that the trial judge, I think, respectfully missed, is there was no other pleadings pending at the time of the dismissal in Katke. So once that was dismissed, there's nothing left. You can't come in later and file a petition. Here, there were other pending petitions.
I'm sorry, and I apologize because I wasn't ready for this, but there was a petition to appoint a guardian, a petition for appointment of a guardian.
Right.
Filed the same time as all of these petitions were filed. And when he moved to dismiss this, not the least of which is filed at the same time that his counsel filed her notice of appearance where she represented one party and not the other. So these were not joint petitions. He dismissed his petition. And, I mean, if we're wrong on that, that's fine. We can go back to our other two arguments, which I think the Katke case is binding in this
And if I could, counsel, the Katke case says, once the trial court accepted the withdrawal of the petition, it lost jurisdiction of the case. Do you know of any rule that requires a trial court to accept or not accept a withdrawal?
No, I think
so
it's
it's
the
not- I mean-
opposite. They don't have to accept a withdrawal.
But that's what
Part of the
Kachke
problem
says.
is-
I don't know why it says that, but that's what it says.
All
So
right,
if you're
well,
relying
part
on
of-
Kachke,
If I can respond, part of the problem here is when we're talking about case jurisdiction, that it's waivable, that's when case jurisdiction is an affirmative defense. This is not an affirmative defense. This is the judge finding that Mr. Cruz dismissed his case and Mrs. Waysky dismissed her case, so she had no jurisdiction by the language that's in, I'll read from the case.
But what do you do again? I think the point that my colleagues are making, we've got a second petition here. I mean, how is this not akin in a civil case, my former life? And a plaintiff dismisses one claim, but keeps in place another
And
claim.
here-
I mean,
here's-
nobody would say, that's it. There's
Yeah,
no
here's the problem.
jurisdiction.
Here's the problem with
Let me respectfully finish. Thank you for letting me finish. But no one would say, that case is over, there's no case jurisdiction, because there's a pending claim still in front of the court. And I think that's what Judge Harris and Judge Edwards are trying to understand, as am I. What about this other petition? Isn't that still alive at the time the court dismisses this? Or not?
I think the answer is no, but if I'm wrong, then you'll tell me I'm wrong. You know, they dismissed, you got to remember, this is not one plaintiff filing a claim against one defendant. This is two pro se plaintiffs filing multiple motions, both pro se, both petitions were pro se, filed at the same time.
And a
that
petition
one
is a pleading, by
It's a
definition.
pleading by two different parties.
And by
Sir, are you
definition.
talking about the petition to determine capacity?
Yes,
Petition to determine capacity is titled Petitioners Michael John Cruz and Helen Waschke do hereby file this petition seeking a determination of incapacity of the respondent and state as follows. They both did it.
never filed, never signed by an attorney.
Well, so what? They filed it. You
Because
don't have
then
to have
now an attorney represents one party that both parties thought this was an uncontested petition, and it became not uncontested.
Okay, so that's fine. Then they each, through an attorney, they each separately filed a petition for guardianship, didn't they?
Yes,
Which was pending at the time, each petition was still pending
Yeah,
at the
but-
time the judge dismissed the case for lack of continuing jurisdiction.
okay, I would say the answer is no, because he dismissed his petition, but if I'm wrong, I'm
What do you
wrong.
mean, when you say no, it's just the fact that they filed something? And again, Ms. Waschke didn't dismiss her part of the petition for a year after they both put in their motions or petitions to be appointed guardian. I mean, a year later. And then they did
Part of
discovery. The
and
case
it's
was
hard
not,
to
I
do
mean,
the
you act like the
timing on this
was,
case.
excuse me, counsel, you act like the case was over. Go ahead.
Part of the problem with going through the timing on this case is the 2 years is made up of plaintiff's attorney and other's attorney taking 6 months off for being in the hospital and other issues in this case. There's a 6-month gap between when the petition was filed and they were going to appoint 3 people to determine whether this person is incapacitated. 6 months later, when they finally get to it, one of the 3 people is not even in Florida. He can't interview this person. And by the way, he doesn't live in Florida. He lives in Arizona. And always lived in Arizona and still lives in Arizona, which is where his mother lives. And that's her address on the petition. That's her address.
That doesn't support a lack of continuing case jurisdiction.
Is
So-
there anything in the record saying that these petitions for guardianship were dismissed? And by the parties?
There are 2 separate voluntarily, not involuntarily.
I'm not talking about the petition for incapacity, I'm talking about guardianship. Difference, right?
Yes.
So is there anything in this record saying that petition for guardianship or petitions for guardianship were dismissed by the parties?
If that's the decision of this court, then I'm wrong. I think it was dismissed when they moved for it, but if I'm wrong, I'm wrong. So what's the alternative? I mean, what's the result?
Well, and we're trying to understand. Please, we want to get this right. We're in the business of getting right answers. I mean, that's the purpose behind this. Is there something where the party said, I think it's clear, the joint petition for incapacity evaporated, but the point of Judge Harris and Judge Edwards, now Judge Jay, is the guardianship petition is still alive, unless there's something out there saying it was dismissed by the parties.
Not one, but two, actually.
Two petitions.
Well, excuse me.
Let me ask, I'm sorry to interrupt, but just because I did so much of this in a previous life, there's a difference between a petition for guardianship and a petition for guardian advocacy. These independent, separate petitions that were filed by the parties were guardian advocacy, right?
Yes.
Okay, that's not guardianship.
No.
At the outset, though, day one, there was a petition for guardianship. Joint
Pro se,
petition.
yes, that's
Joint
correct.
petition for guardianship. That's never been dismissed by anybody. Right? Well, actually, I should say, your client, when she did her voluntary dismissal, put in hers that she dismisses her portion of the incapacity petition and the guardianship petition. Mr. Cruz never did that. So his portion of the joint guardianship petition, not the guardian advocacy, but the guardianship, has always been pending. Does that sound right?
Well, it's certainly something that was never raised in the briefs, I'll say that. What you're arguing now was never discussed, never argued at all.
I'm not arguing, I'm asking.
Yeah, it makes perfect sense, and I understand you want to be right. And I'm trying to review the order that was issued by the trial court. And the trial court relied on the Bursky case. I've read it, reviewed it, said what was happening. Finally, I think after some various and sundry mediations and meetings and trying to resolve this case wasn't going to be resolved. So finally, Helen Waschke dismissed her case, thinking that the case was then over, because that's what she assumed was the case, and they had a case that the trial judge ruled on. And you're right, they didn't move for rehearing to address that case. It's a case out of this court that makes it clear when you dismiss it, the trial court has no jurisdiction to hear further petitions or anything else. Now, if you're saying that petition was pending, how does that coincide, or how did they pursue it? No. Did they seek a hearing on it? No. They did nothing. They filed a separate individual, and remember, this is two people not represented by an attorneys, filed a pro se thing, and on the exact same day, an attorney files a different thing, and then they file a motion for a different guardianship, relying on the exact two documents that supported the original petition. So this gentleman, this incapacitated person, there are two letters from his doctor attached to the petition for guardianship, and there's two attachments to the limited guardianship. And they both say the same thing. He's 30 now, he's going to be 30, next week 31 years old. He can't brush his teeth, he can't cook for himself, he can't live by himself. He needs to be taken care of. His mother has taken care of him for 20 years. He hasn't been in Florida for decades, which his attorney told the judge that. The judge knows that. It's in the record. It's in the Melanie Burpee's report to the court. It's in the record. Read it.
Well, I mean,
We
to be
have
fair,
read it, counsel.
Your
How
client,
do we know all these things?
I know. So
your client put into the joint petition under penalties of perjury that
yes,
that he lived in Florida.
yes. Well,
Well, that's what it says.
she lived in Florida when she signed that document. Yes.
That the son lived in Florida. He was a resident of Florida. Now she's filing something that says he's never lived in Florida.
The father lived in Florida. And the record makes absolutely clear that there was liberal visitation over 20 years. This is not something that happened this time. They did this so he could get dental work. Why? Because he's 6'1", 220, and they had to sedate him, and they had it done at Shands. Now, did he live in Florida? Yes. He came to Florida, stayed with his mother, who has relatives here, stayed with his father. But since this whole started taking place, he hasn't been to Florida. He hasn't seen his father in however many years because of this. So if you want to send it back, fine, but he doesn't live in Florida now. And if you're saying, what, they served this incapacitated man who was appointed an attorney when it was an uncontested case. They didn't appoint an attorney to be his representative in a contested case. They asked for a new attorney to be appointed. Oh, well, he's already been appointed an attorney. Well, does that, I mean, I'm an attorney. You represent the person who appointed you. So he was appointed, Ms. Burpee, was appointed to be an uncontested, who wants to be the guardian of this child, both parents. And then within the exact same day, same filing, one attorney represents one party and not the other. They file a different, supposedly limited attachment with the same documents attached. So when you look at and I agree that the limited guardianship they're asked for does have lesser requirements, but they didn't identify those requirements at all in that petition. And the this is the 5th District, the 5th Circuit, which is where this is, doesn't have a form for this kind of limited capacity. You can do the petition for guardianship, it's online. I see I'm out of time, so thank you. I appreciate it.
Thank you.
And I apologize if I interrupted you. I apologize.
Rebuttal?
Yes, Your Honors, thank you. Admittedly, 744 and the Florida probate rules aren't very clear, very helpful when we're dealing with a situation where we have a contested guardianship, like this particular case, or even a situation where it starts out as a plenary guardianship and the parties later determine that guardian advocacy may be a more appropriate alternative. And I believe, Your Honor, Judge Harris, you had stated, the definition of a guardianship. We also have a conflict there because the Florida probate rules under 5.015B6 refer to guardianship as a formal guardianship, a plenary guardianship, or a guardian advocacy. So unless a rule indicates otherwise or a statute indicates otherwise. Admittedly, there is also no rule regarding amendments. So in the event that Ms. Waischke and Mr. Cruz wanted to amend their petition, there's no rule governing how to do that amendment. Back in 2023, when both parties filed their petitions for guardian advocacy, Section 393.12, which tells us what needs to be in a guardian advocacy petition, was different than its current iteration. It was amended in 2024 to be closer to what we find in 744 regarding the petition for incapacity. So arguably now it may be a little bit easier to amend, but back then they had separate and distinct requirements meriting the filing of a new petition. And lastly, Your Honor, circling back to my third point regarding the law and public policy, I believe counsel referenced that this is a young man that needs to be taken care of, right? He can't brush his teeth, he can't care for himself. If something were to happen to his caregiver, he would be listless. He would not be able to carry out the tasks necessary to take care of himself. And that is why both parties came before the lower court seeking redress of that particular issue, seeking the authority, and also setting up a plan for this particular young man, for Vinny, so that in the event something were to happen, there was a plan in place and an individual could meet his particular needs. If there are no further questions, Your Honor. Thank you, Your Honor, Chief Judge.
All right. Thank you. That concludes our first case of the morning. And if counsel would just allow counsel in the Cruz case to leave. before you start to move forward, that would be appreciated. All right, please come forward. Our second case of the morning is Hardin v. Hardin, case number 2024-2543. Counsel for the appellant, are you ready to proceed? All right, please come forward, announce your appearance, and then tell me if you would like any time for rebuttal.
Yes. Good morning, Your Honors, Mr. Carlisle, and may it please the Court. Tom Skolko here on behalf of the appellant, Dr. Marcus Hardin. I'd like to reserve 5 minutes for rebuttal.
All right, Mr. Skolko, please proceed.
This case ultimately presents two fundamental questions. What is the holding of the Florida Supreme Court in Caldwell versus Division of Retirement? And how does Caldwell apply to the presumption of equal time sharing that the legislature added to Section 6113 in 2023? Caldwell is not a complicated decision. It simply holds that where there is evidence supporting a legislative presumption that is an expression of social policy, that presumption can only be overcome by clear and convincing evidence, even if the standard for rebuttal set by the legislature is less. This is clear from Caldwell itself and from the First District's decisions in Punske and in Jones versus Crawford. Contrary to the appellee's claim, the legislative standard for rebutting the firefighter presumption in Caldwell, which was Section 112.18, was not clear and convincing evidence. It was competent evidence. That's clear from the decision. This fact alone establishes the incorrectness of the appellee's interpretation of Caldwell.
Counsel, can I ask you a question? You agree that there was conflicting evidence on nearly every issue going towards the time sharing, correct?
Correct.
Right. And with the conflicting evidence, who is supposed to decide which evidence is credible and worthy of belief?
Well, it's the trial court obviously makes the determination of credibility.
But are you, the way I read your brief, and I'm not sure that's the way you intended it, but you essentially said if there was any conflicting evidence on any issue, or maybe on all issues, I'll say this, if there was any conflicting on all issues, then the judge had to declare a tie and go with the statute that said the presumption is equal time sharing. Is that boiled down? Is that basically what you're saying?
Not exactly.
Okay.
Caldwell holds that where there is credible conflicting evidence presented on both sides, that generally the presumption should control. Here, the trial court, yes, the trial court resolved some factual disputes in favor of the wife, but there was clearly credible evidence submitted that the trial court adopted as credible in support of the presumption. There was Dr. Hardin's testimony himself, there was the testimony of the principal, and most importantly, there was the testimony of the court-appointed expert, Dr. Flens.
And again, if I can interrupt you here, on the Caldwell case that you rely on so heavily, that was a statutory presumption for firefighters, specifically if they had a heart attack, that it would be presumed that it was job-related. The finding here, the finding was made by the district court, not a trial court. The finding was made by a district court that his heart attack was caused in part by arteriosclerosis that may have been stressed out by his job performance. Is that right?
I don't think that's exactly right. I think in Caldwell, the workers' compensation judge resolved conflicts in the evidence, the medical evidence. There was conflicting medical evidence as to whether or not the heart attack was, or the condition was caused by work, or it was a genetic or congenital cause. The workers' compensation judge resolved that conflict in favor of it being not work-related. The district court affirmed that finding, saying it was supported by competent substantial evidence. And then Mr. Caldwell appealed that to the Supreme Court, saying that the trial courts or the workers' compensation judge's resolution of that factual issue is not sufficient to overcome the presumption, because competent, credible evidence was presented in support of the presumption.
And in Jones, that was a very kind of scientifically oriented situation of paternity. If the FLA test came back at 95% that this fellow's the father of that child, he's presumed to be, the statutory presumption is you're the father of that child, unless you can really prove otherwise. And in the Jones and Crawford case, Ms. Jones said, yes, we had sex. The test result was 98.23% that you're the dad, and his defense was, never had sex. This was a matter of immaculate conception. If I'm the dad, it was immaculate conception because we never had sex. And the 98.3 or 98.23, I don't know where that came from. And there, the judge looked at that evidence and really ignored the 95% factor, didn't he, or she?
Well, that's correct, but there was the appellee, I guess Mr. Crawford, did offer more than just his bare denial. Mr. Crawford also offered, I believe that that
She had another lover.
She had another lover, and that
She claimed to always use protection.
and she claimed to use protection, but and also the trial court found that Jones's testimony lacked credibility. So the trial court's role as fact finder in Jones was exactly as the trial court's fact finder here. The trial court resolved conflicts in the evidence, resolved them in favor of the appellee, just like the workers' comp judge did in Caldwell. But in both cases, because competent and credible evidence was presented in support of the presumption, and in Jones that evidence was that I think Ms. Jones testified that she frequently had relations. And also, Ms. Jones's mother testified that Crawford paid them money regularly as well. So there was evidence presented in support of the presumption. The trial court's resolution of that evidence against Jones and against the presumption, even though it was supported by competent substantial evidence, by a preponderance, it clearly would have met the preponderance of the evidence test in Jones, correct? I mean, but that wasn't enough.
I have an esoteric question. Can you have competent evidence that's not substantial, and conversely, substantial evidence that's not competent? Is that possible?
I suppose it is, because it's two separate requirements.
So, and thank you. So there are two different analysis points for the trial court, correct? Competency and whether there's substantial evidence. Two different things.
Correct.
And here, and again, I'm just looking at Tucker, which is one of our cases, that the court has broad discretion in evaluating competent substantial evidence. You would agree with that too, would you not?
Absolutely, but for the fact that this was a legislative presumption evidencing social policy, this case would have easily been resolved by the competent substantial evidence standard. But because it's not, because this case does involve a legislative presumption that's an expression of social policy, to overcome the presumption takes more than the rebuttal standard. That's what Caldwell holds. That's what Punske, which the First District construed Caldwell, interpreted Caldwell just exactly as we are. In fact, they certified a question to the Supreme Court. Here's what the First District said about Caldwell. Even though we are bound to follow Caldwell, which we do here, we are concerned that the court in Caldwell added a clear and convincing burden of proof to Section 112.18.1, where the legislature provided for rebuttal of the firefighter's presumption by the introduction of competent evidence. So the First District interprets Caldwell exactly as I do. exactly as we argue in our brief, that under these circumstances, more than just rebuttal by the legislative standard is required to overcome the presumption. Does that it?
In Caldwell, the court says where there's a rebuttable presumption, which I think is what we have here, correct?
Correct.
That the presumption doesn't just disappear when other evidence comes in. It is not overcome until the trier of fact, our judge, believes that the presumed fact has been overcome by whatever degree of persuasion is required by the substantive law of the case. And here that would be by the preponderance of the evidence.
I disagree.
Okay, why is that?
And that language in Caldwell, and I know the appellee relies on that language as well, I think that misunderstands the decision. That language is expressing language is expressing the circumstances when no evidence is presented in support of the presumption. Then merely meeting the rebuttal standard would be sufficient. That's why the court in Caldwell created a division. It said where no evidence is presented in support of the presumption, then the rebuttal standard is sufficient to overcome it. But where evidence is presented to support the presumption, more than the rebuttal standard is required. And I think that's really a necessary, I would say, inevitable, logical consequence of the Supreme Court's discussion of the various effects of presumptions under Florida law. A presumption that is an expression of social policy has to be given weight, even if rebutted. So in this case, the judge found the wife's evidence was, we know, at least 51% persuasive over the husband's evidence. But now we add in the presumption, right? If the same evidence that the trial court found satisfies the preponderance of the evidence without the presumption is sufficient to also satisfy it with the presumption, then the presumption is not being given any weight. And that's really what Caldwell's about. It's to ensure that important legislative presumptions are given weight. And the only way to do that is when evidence is presented in support of those presumptions, that they can't be overcome merely by the rebuttal standard by the legislature. They can only be overcome by clear and convincing evidence. And I would also like to briefly address our argument about the two findings that we contend are not supported by the record that the trial court made about the tardies that the children were having under Dr. Hardin's custody, and about the Fast Forward program. The trial court's finding about the tardies, it's important that the timing of that is very important. The trial court found that after Dr. Hardin was informed about the problem, that he didn't fix it, and that the children continued to be come to school late. That's not the case at all. The record doesn't reflect that. The only evidence of tardies after Dr. Hardin was told about the problem was Principal Hager's testimony that the children were tardy 6 days in the school year and absent 1 day. That's not evidence. That doesn't reasonably establish that Dr. Hardin can't get the children to school on time. And it certainly doesn't establish that that was any problem that interfered in any way with their development or their education. In fact, the Principal Hager testified to the contrary. So that finding simply is not supported by the record. And similarly, the finding by the trial court about the Fast Forward program, it's true, part of that finding is true, that Dr. Hardin was unwilling to have the children participate in this program, or to have the child LH participate. But what's not true, or not established by the record, is that his unwillingness had any impact on the children. In making that finding, the trial judge relied on a report card, I guess for the 2024 year, that indicated that I'm surprised that LH hasn't made more progress since Fast Forward was recommended in 2023, in July of 2023. But LH hadn't even been in the program, and it wasn't Dr. Hardin's fault. The program didn't even start till after that was given. So the trial court clearly was basing that finding of some sort of detriment to LH based on the husband's lack of participation. That simply isn't supported by the record. And I think I'll reserve the balance of my time for rebuttal. Thank you.
All right, that will be fine. Thank you.
Good morning. May it please the court? Excuse me. Your Honors, my name is Chris Carlisle. I represent the appellee, Ms. Harden, in this case. Excuse me again. Your Honors, this is a case where the trial court did its job. Trial court was aware of the statute involved, was required, was aware of what the statute required. The court heard 2 days of testimony from 10 witnesses and then issued an incredibly detailed, single-space, 40-page final judgment analyzing the factors under 6113 that it had to analyze. The court did its job. What does the other side claim the court got wrong in this case? As I understand it, their position is the court should have been aware that a 46-year-old Supreme Court case dealing with a firefighter statute should have controlled the court's determination in this case. Several problems with that. The first being that case, throughout the history of this case, which was started in 2022, as far as I can tell, was never mentioned. Never. That was never argued to the trial court. They say in our motion for rehearing, clarification, etc., the essence of this argument was there. It's not. If you look at page 2802 of the record, there's one paragraph that essentially says the statute changed and mundane findings like this shouldn't be enough to overcome it. That's a far cry from what I think they're arguing now, which is despite the fact that the statute says that preponderance of the evidence is what the court actually is supposed to use, the court was supposed to disregard that and say, no, clear and convincing evidence. Clear and convincing evidence is not argued anywhere in that motion for rehearing, and it wasn't argued below at any point. So the waiver issue is enormous in this case. Secondly, I struggled, as Judge Edwards did, with exactly what they were saying and what the court should have done. Is it clear and convincing, or is it the tie goes to the runner type of situation, as Judge Edwards referenced? That's what the impression I got. So what does that mean? That means in a family law case where you have extensive evidence clearly involving numerous factors, any conflicting evidence, they win. That's not what the statute says. That can't be what the legislature intended. It frankly makes no sense. So what do we have here? We have a trial court looking at the statute, 40 pages of this. You got it wrong, trial judge, because you read the statute as it reads. I filed a case that I believe Judge Harris and Judge Jay, you concurred in, the Peccia case from a couple years ago, talking about and recognizing Ham, of course. The reality is that starting in 2020, the supremacy of text principle came into play. So I think what we're saying here is the text says what it says. And for this court to agree with the other side, it would have to say, we're ignoring Ham. The statute doesn't actually require a preponderance of the evidence. It requires clear and convincing evidence. It doesn't say that, but we think, based on this firefighter statute case from 46 years ago, that was what was required here. I don't see how the court can write that opinion and ignore Ham. Ham came out in 2020. The Penske case, I believe it was Punske that they cite, yeah, the first ECA said, we don't understand the Caldwell decision because the statute clearly says clear evidence, but the court imposed this higher standard there and certified it to the Supreme Court, which didn't take it. But if you look at that certification, it deals specifically with that statute. And all the time, in all these 46 years, we don't see a lot of cases applying Caldwell to these plethora of presumptions that exist in the law. So I think the position on many levels is strained. I think that the trial court did exactly what the trial court was required to do here. I think in order to send it back or reverse it, this court has to disregard Ham, has to say the statute requires something that it doesn't. And frankly, they make the argument that the legislature had to be aware of Caldwell, and it's presumed that they knew what Caldwell said when they changed the statute a few years ago. I think a better way to look at that is the court was certainly aware of Ham, which came out 5 years ago when they changed the statute. And if they were aware of that, why would they pass a statute that says preponderance of the evidence, but that's not really what we mean? That's not exactly what the court's supposed to do. It's supposed to be clear and convincing. Frankly, again, the specific argument was never raised. It was never brought to the trial court's attention. The trial court did its job. The trial court went through the factors ad nauseum for 25 pages of these things. A final point on this, and something for the court to consider, is that in both Caldwell and Jones, you're talking about a very specific and very narrow statute. You're talking about the firefighter presumption that says if they have these diseases, this is the presumption. In Jones, you're saying here's the paternity test statute, 95%, boom. Those are very specific situations. What we're talking about here is a family law case where the court has to consider extreme number of factors that go into this decision. To suggest that conflicting evidence on any of those factors somehow renders the decision in their favor is simply wrong. Turning, if I could, to the 2 points. Again, you have this, what happened in this case was you have essentially a summary that the court gives that focuses on 4 factors that were kind of outstanding to the trial court. The alcohol issues, didn't hear a word about that. Overwhelming evidence of that. Court also talked about stalking. We don't want to talk about that. They don't mention that. Court talked about the communications between the parents and the father's nature in those communications. Not going to talk about that. Court talked about the condition of the father's home, which Dr. Flynn said was striking. They don't want to talk about that. They want to talk about 2 things: the Fast Forward program, where the husband admitted at his deposition and at trial he doesn't have the child participate in it. That's it. There's no doubt about that, and the court said, I've heard testimony that this is important for the child's development, and the father admittedly doesn't do it. They say that the court got that wrong, but in reality, if you look at this, they say that the court blamed the father for something here, and they cite to page 2812 of the record about its 2024 report card. In our answer brief, we pointed out nothing on that page that they cited supports that, and they didn't change it in their reply brief. Finally, they talk about the tardies issue, and there's no evidence that in the current school year that the father was responsible for this. Yes, there was. There's his deposition testimony, which we cited, where he acknowledges that. There's business records that were put into evidence in this case that we cited and went to in our answer brief, where all of this in the current school year was there. So yes, their position is he was tardy with the children many times in the previous year, but the court got it wrong because in the present year there wasn't evidence, yet there clearly was. Despite all of that, the reality of this case is, what was the trial court's job? What was the trial court supposed to do? The trial court was supposed to read the statute, spend the time with the evidence, go through the testimony, and issue an order citing the statute, which it did, and saying, based on all of this enormous mountain of evidence that I'm considering on numerous issues, I find that the presumption has been overcome. It's exactly what the trial court did. There's no error here, Your Honors. Thank you very much.
Thank you, Mr. Carlisle. Rebuttal?
Thank you, Your Honors. Overcoming the presumption is not the same as rebutting the presumption. Caldwell does not conflict with the statute. That's what I think everyone's missing. Caldwell talks about what it takes to overcome a presumption where competent, credible evidence is presented in support of the presumption. The legislature is talking about what it takes to rebut the presumption. Rebuttal is just gets you in the door, but it doesn't get you over the line under Caldwell. And the reason is because the essence of Caldwell, and it was applied in Jones, it was also discussed in the Supreme Court's decision in 2012 in Warfel as well. And so it is clearly good law, at least on that aspect of Caldwell, about the clear and convincing standard when you're dealing with legislative presumptions that are an expression of social policy. But the bottom line is, under the Appellee's view of this presumption, what's changed? Before the presumption of equal time sharing was enacted by the legislature, a trial court could find, by a preponderance of the evidence, that unequal time sharing was in the best interest of the children, or that equal time sharing was not in the best interest of the children, and award unequal time sharing to the parent based on a preponderance of the evidence by 51 to 49. And after this momentous change to the law, that other states, that's taking hold in other states around the country, that was the subject of so much discussion, after this change, according to the appellees, a trial court can still find, by preponderance, can still award unequal time sharing to a parent based on finding, by a preponderance of the evidence, that unequal time sharing is in the best interest of the children, or is not in the best interest of
I'm
the
going to take you back to Caldwell if I can, because I'm not reading it or understanding it the same way you are, and I want to give you the opportunity to enlighten me.
Thank you.
But in Caldwell, I'm looking on 441, it says the statute, meaning the firefighter's statute, is the statute cast on the employer the burden of persuading the trier of fact that the disease was caused by a non-occupationally related agent. So, city, retirement fund, whoever it is, trying to avoid paying the firefighter with a heart attack, it's your burden to prove that this was not job-related. It's not the firefighter's burden to prove it is. Can we take that and go here to the dissolution case and go, okay, wife, if you want to have unequal time sharing, it's your burden then to prove that.
How is
that
that
what Caldwell says?
Well, Caldwell says that, but remember, in Caldwell, the workers' compensation judge applied that test, found that the evidence against the presumption carried more weight than the evidence in support of the presumption, and the first district,
the presumption would be meaningless if the only evidence necessary to overcome it is evidence that there was no specific occupationally related event. So here, if you go, okay, wife, you want unequal time sharing, you have to carry the burden. It's your burden to carry. Am I missing something there?
how, interpreting it that way, how is it any different than before the presumption went into effect? The wife could still get unequal time sharing by proving, by preponderance of the evidence, that unequal time sharing was not, was in the...
What's the only burden of proof mentioned in this section? Now, that's, again, isn't it preponderance of the evidence?
It's preponderance, well, there's two burdens. There's the general burden under 6113 without the presumption, which is that, if you want to establish something, you have to establish it by preponderance of the evidence. And then there's the presumption, which adds a rebuttal burden, which is also by preponderance of the evidence. But when there's but what Caldwell, I think, clearly holds, and the First District agrees in Punske, is that where evidence is presented in support of that presumption, that merely meeting the rebuttal standard is not enough, because that wouldn't give meaningful effect to the presumption. There wouldn't be any change. The legislature didn't do all this just so the judge could add a boilerplate sentence to the order saying that, well, actually what happened here was...
40-page judgment?
Well, yes, there was a 40-page judgment, and the judge went through all the factors and said, and made the finding that unequal time sharing was in the best interest of the children. And then in one sentence, a boilerplate sentence says, in consideration of this finding, I also find that the presumption of equal time sharing has been rebutted. That's just a boilerplate. There's no weight being given to the presumption in that analysis. That's what Caldwell's all about, is that important legislative presumptions have to be given weight, even when they're rebutted. Where's the weight given to this presumption?
Okay, thanks.
All right. And one other point I'd make about the two evidence issues we raised. Both the Fast Forward program and the tardy issue were clearly very important to the trial court, because the trial court's fashioning of time sharing barely gave any time sharing to Dr. Hardin during the school year. but gave all of it during the summer months, which shows that those two factors, about the tardies and the thing, were clearly very important. And the great discretion that the appellee points out that trial courts have, there's a corollary to that, which is that we don't know what the judge, exactly how the judge weighed these factors. And if the court made a mistake in even one of those findings, under Florida's harmful error test set forth in Special and Sedler, the burden shifts to them to prove that that mistake didn't affect the outcome. How can they meet that burden if we don't know how the judge weighed the factors? So I think that discretion, it's like a double-edged sword. Yes, they have that discretion, but if they make a mistake, they're not going to be able to meet the harmful error test.
All right.
Right.
Thank you.
Thank you very much.
That's the end of our oral arguments this morning. Thank you both. We'll be in recess.